Hey everybody. This is a booming mic. Let me stand back a little bit. My name's Dan Hunter. I'm the Dean here at the Dickson Poon School of Law, for those who don't know me. And it's my great pleasure to welcome you here tonight for the inaugural addresses of Professor... I'm so broken up. Professor Anne Mumford and Professor Irit Samet. Let me begin by introducing Anne, a scholar who's made it her mission to reveal the social and political soul of tax law, and has spent her career showing us that taxation is far more than fiscal mechanics. It's a window into power, identity, gender, and the way we construct social belonging. From her early influential work, Taxing Culture, to her feminist analysis of tax policy and her work on the new fiscal sociology movement, Anne has consistently brought law into conversation with culture, ethics, and the structures of inequality. She is the leading voice in her field, respected not only for her scholarship, which has shaped courts and classrooms alike, but also for her tireless commitment to students, colleagues, and the broader academic community. She has a distinguished career that has moved through Cardiff, LSE, Queen Mary, and now we are lucky enough to have her here at King's College London. And I have been extremely fortunate to enjoy the benefits of her counsel in her role as Vice Dean with me, but others have also, other deans have enjoyed her counsel as well. And is one of the country's foremost scholars on law and taxation and a powerful advocate for using tax law as a tool for social justice. Tonight, we also have another speaker. So tonight is a dual inaugural, as you would all be aware, and it is my equal pleasure to introduce Professor Irit Samet, one of the most original and elegant thinkers working at the intersection of equity, trusts, and moral philosophy. Her scholarship explores some of the deepest questions in legal thought: how we justify trust, what conscience means in modern law, and how morality weaves through legal doctrine. Her book, Equity, Conscience Goes to Market, has already become a touchstone for scholars, and her editorial work on the Philosophical Foundation series has helped elevate and reframe how we think about fiduciary duties, equity, and liberal property regimes. With a DPhil supervised by the legendary Joseph Raz and a career that has taken her from Oxford to Essex and now firmly rooted at King's, where she's also helped me in a vice-decanal role, Irit has become a mentor to many, a leader in academic governance, and a trusted voice in debates around legal ethics, private law, and the very nature of justice. We're fortunate to have both speakers talking tonight because it's rare to hear scholars whose work captures so elegantly the old adage about life's only certainties, death and taxes. And through her scholarship on tax law has shown us how fiscal policy is inseparable from who we are and who we're allowed to be under law. And Irit, in turn, has outlined the moral architecture of equity and trust law, including how we navigate death, legacy, and the obligations that bind us even beyond the grave. Together, their work reminds us that the legal questions surrounding death and taxes are not just technical, they're human, ethical, and deeply personal. And tonight, we're fortunate to hear from two people who've dedicated their lives to helping us understand just that. As is traditional with inaugurals, there will be no Q&A, and unfortunately, I have to race off to another engagement, and so Professor Paul James Cardwell will introduce or welcome to the stage our second speaker. But bear in mind, as he will remind you, I'm sure then, that although there are no Q&A, you are always free to stay for the drinks reception afterwards and ask our speakers anything that comes to mind. So let me first welcome to the stage, on behalf of you all, Professor Irit Samet.
Dan, for this kind introduction, and thank you, Paul, for initiating this lovely series of inaugural lectures. Special thanks to my family who is here to support me, my husband Michael and my daughter Naomi, my son David and my daughter Hannah. I wouldn't get anywhere without your support and love. The thought I would like to share with you today are about the power which equity grants those who are fortunate enough to live in common law jurisdictions. And that is the power not only to decide who is going to be the owner of the property you owned until you died, but also to have a say in how this property is invested, enjoyed, benefited from after this unfortunate event of death. Now, I chose this topic because it represents what I was trying to do throughout my legal career as a legal philosopher. And that is that the moral perspective, that looking at the law of property, looking at law of equity, and in particular the law of trust as of late, from a perspective of moral philosophy, can yield fresh, interesting, maybe even important insights into these areas of law. Now, you all know that these areas of law have quite strong technical aspects to them, and this may have deterred people with theoretical bent from engaging with them deeply. But there's another thing that I hope you will see from this lecture today, and I was trying to show in my work, that actually, as Dan said, these topics, these subjects, these areas of law touch the most fundamental questions about what we owe to each other, what it means to be a free person, and how do we build a society that is based on respect for other people's humanity. So, like a good philosopher, I'm going to start with a presumption. And the presumption is that the right to leave your property to your loved ones or to your favorite cause after you die, to decide who is going to be the new owner after you die, can be justified. You can have a liberal, just regime of property law where property upon death is not going back to the community, but rather goes to a new owner according to the decision of the owner. Now, this will usually mean that in order for it to be just, that will usually mean that you're going to have quite hefty death-triggered tax, what we call inheritance tax. But if we have this package, we can have a just regime of inheritance. This is my presumption. It is not, it doesn't go without saying. A lot of people reject that, but I'm going to talk today about a different power. And that is not only to say who is going to be the new owner, but also to say what they will do with the property, how they will use it, how they will benefit from it, even after the previous owner's death. Now, we will see that the new owners have all the reasons in the world to complain about that, about adding a new options that, for example, in civilian systems we don't have. That is, either leave it to me or leave it to someone else. Equity adds a different option, and that is, leave it to me, but tell me what to do with it. So this is the power that we're going to focus on. This is a power that we would call an incident of private property. And like any incident of private property, it needs to be justified, right? Because we're giving private control to people over resources that everybody else would have liked to enjoy, and therefore we need to justify it. Now, as people who engage in the theory of property law know, there is a menu of justifications that have been offered for about 2 millennia, starting from Aristotle, going all the way to modern law and economics, of how we justify this institution of private property. And if you have a new incidence of private property, you just go through the menu and you see whether it can be justified according to one of those. We're not going to do this exercise now because we don't have time. But I am going to go very briefly into two of the perhaps most successful justification for private property, and see how it is actually quite difficult to use them to justify what I'm going to call a posthumous trust. Posthumous trust, I'm using this expression to mean trusts that run after the death of the settler, regardless of the question when they were settled. Let's look a little bit about economic efficiency. So the thought is very familiar. If we allow people to keep at least some of the products of their labor, they're going to work very hard to produce wealth for themselves for egoistic reasons. So we have, and that will increase efficiency. With inheritance, the thought is that if we tell people that even after you work so hard to produce so much wealth, more than you could use throughout your lifetime, you still need to work harder. We still incentivize you to work harder because you can leave the surplus to your loved ones or to a cause that is dear to your heart. Okay, so we have a set here of empirical observations that are not very easy to justify. Not to justify, but to prove. But it makes sense that people will indeed work hard to produce wealth under these conditions. But this really cannot be applied to the power that we are talking about the power that a posthumous trust allows us, that is to have a say in what will happen to the property, because it's very hard to see how people will work even harder if we tell them not only you choose who is the owner, you also choose what will be done with the property. So one really significant justification for this incidence of private property cannot be used in this instance. Let's leave it aside. Let's talk a little bit about autonomy. This is also one of the perhaps most powerful justification for property, for the institution of private property. The idea, again, is quite intuitive, and that is that people who have control over the physical environment around them, in a way private property allows, are more autonomous. They're more able to write the story of their life if they're granted this kind of control. Now, of course, applying this directly to the posthumous trust is a bit difficult, because to say that we are increasing your power to write the story of your life through the posthumous trust is a bit difficult because you are dead. Yeah, so the story of your life is basically ended. So this also doesn't work, at least not in a straightforward way. Now, both of these justifications also have a flip side, because we have the incentives that we create, the set of incentives we're creating for the owner. But what about the next owner? Of course, with inheritance, if you think about economic efficiency, the children or the people who are set to inherit, that will know they're going to inherit a big sum after the death, the last thing they will do, if they're sensible people, is work hard to produce wealth. Why would they work and slave and do all the marking the police sending by their way and so on, right? They can rest from this day on. So the economic efficiency of a regime of inheritance is questionable. And of course, the posthumous trust is also problematic from this aspect. But from the perspective of autonomy, the posthumous trust is even more difficult. The flip side is even more difficult, because the increase of autonomy that is given to the original owner, that is to have a say in how the property is used after their death, surely detracts from the autonomy of the next owner, because they will not enjoy now the powers that normal owners have to decide what to do with the property, how the property can serve their agenda, their plans, and their aspirations. So this is a good way this is a good segue, as Yael taught me to say, into the story of the James family. I think that I'm going to talk a little bit about the James Family Trust in order to show you the problematics of the posthumous trust and what happens there. Okay, so in his will, William James Sr., the grandfather of Henry and William, who was a very wealthy Irish merchant, self-made man, died in 1832. He was very critical about the ideas of his son, that is the grandfather of William and Henry, about how to bring up his sons, to give them liberal education and so on, and teach them to be artists. He didn't like that at all. He thought he was just sending them completely off the way. And therefore, most of his money he left in a posthumous trust, in which he's giving excessive power to the trustee to decide what will be done with the money. And he says, and he explains, that he confers on the trustee extensive and extraordinary power in order to punish idleness and vice and reward virtue. So the trust, the biographer of William Sr. says, reads as some sort of last judgment, a grim final reckoning of whose most arresting feature would be the inevitable, if long delayed, punishment of the damned. So the children, of course, the son, of course, was very, very unhappy about the way the inheritance is locked into this trust. They took the trust to the courts of chancery in New York, and they had two lines of argument. The first one was looking beyond the kind of controversy within the Williams family. And they said, look, we have here actually a collusion between two ways of looking at the relationship between people and the property. One way is, please forgive me about that, is the English way of the 19th century. And he said, what you see there is that the individual doesn't really matter much. All that matters is the lineage. You are just a link in a chain. And therefore, your plans, your aspiration don't matter much. What matters is that the property stays in the lineage, in the family, and is passed through the generation in a way that preserves the power in the family. And they say, no, in America, we are the land of freedom. We look at property in a very different way. Each owner is equal to the former owner. Each owner is individual, and they have their freedom. And this is how we should look at them. And they cited Emerson, who was saying the dead hand, right? The idea that the dead can control the living. In particular, in the form of property, is one front in a bigger struggle between the party of memory, that is England, and the party of hope, which is the US, the new US. Sadly, this line of argument didn't make any impression on the court, but a different line of argument, there was a very technical argument about the rules of perpetuity. If you don't know what these are, trust me that you don't want to know. But that one was actually quite successful. And the will was struck down, and the father could use the money to send William and Henry to Europe. Both of them said that their philosophy and literature was deeply influenced by this kind of education that they got through the money. In the photo here, you can see William and Henry sitting there. The father is there with a hat, and I'm sure you can tell who is the grandfather. Okay, so what we learned from here is that, I think, is that the motivation for creating this kind of posthumous trust, the need to have a say in what will happen to the property after one's death, can be a result of highly questionable attitudes to one's life and to one's property. One is obsession for control, right? You can't let go. Not only in your life, but also after your death, you want to be able to say what will happen to your property. The other, perhaps more subtle, is maybe a delusion about death. So whatever you think about the afterlife and the next world, in this world, you need to understand your role is finished once you are dead. And these people may be deluded about that. They don't understand that having a say in something after your death, it's meaningless. Right. So in the chapter that this talk is based on, I'm making two arguments. One that actually want to justify the posthumous trust and show that actually it can be an expression of benign, at least benign, if not positive attitudes towards one's property. One of them is tackling the delusion about death. I'm looking at the psychology, some psychological research, that shows that, in fact, the need when you're actually writing a will, the need to be able to say what will happen to your property may be actually a response to an acute awareness of one death. So there's no delusion there. I'm going to leave this aside because I don't have time to do this one. I'm going to focus today on the other argument about the obsession for control. And the bottom line will say that actually we do have a stake in what happens after our death. And expressing this stake through the property is actually a positive, it can be a positive and benign way of expressing the stake that we'll have in what happens to the world after we die. All right, so this is the question. We're asking, can the power to settle posthumous trust be interpreted as giving effect to a legitimate interest of the owner, the settler? So we need to ask a preliminary question, and this is it. Can we harm the dead? So a person has died. Can you harm them? Joel Feinberg says the following: mere inanimate things can have no interest, and what is incapable of having interest is incapable of having rights. A bit difficult to argue with that. But Aristotle has a different intuition. And he says, the dead man is popularly believed to be capable of experiencing both good and ill fortune, honor and dishonor, prosperity and the loss of it in exactly the same way as if he were alive, but unaware or unobservant of what was happening. So think about what happens if after you die, all the books that you've written, everything you've done, people will say, well, this is really rubbish. Nobody ever reads it. And it's not true. They're actually quite good. It's rubbish. Nobody ever. Did they harm you? Many of us will say, well, in a way, actually, they did. So what I want to do from now is to follow Aristotle's line of thinking. The wonderful New York-based philosopher Samuel Scheffler says the following: there is something approaching a conceptual connection between valuing and wanting what is valued to be sustained or preserved. Now, when a philosopher says conceptual connection, we are talking money, right? We're very, very serious about it. And what he wants to show is that if we believe that a certain aspect of the world is valuable, or we created a value, and we take this value seriously, we're really committed to this value, then almost necessarily what will come with that is a desire that this value will proceed, will continue to exist and to be valuable along a natural course of the life of this value, so to speak, regardless of the arbitrary date of your death, of the valuer's death. And this is what we want to show now. The way to show that, he says, is if we make a little exercise, like a little thought exercise. Think about how you feel if I tell you the following. You will die in old age, surrounded by your loved ones, with no pain, all good. However, 30 days after you die, everything in the world will perish. Now, those of us who have children, I think even those of us who have children will be able to distill the pain that we feel about the children not being there anymore from the pain that we feel about, and the terror actually that we feel about the thought that everything will perish. We're not talking about pain. It will just stop. It will just cease to exist. Now, this dread is not about our death, because we said you died normally, right? You died actually the best death that you can think of. It's about people dying that you don't even know. It's about the fact that all the aspects that you valued in this world have stopped and ceased to exist. And what this shows is that it is that there is a kind of very close connection, as we said, between wanting the value to continue and commitment to this value and wanting it to proceed beyond some kind of arbitrary end, be it our death or 30 days after our death. And moreover, Scheffler says that most people will say that actually, if they know that this is what's going to happen, they're going to find it difficult now to set value on aspects of the world and create. Think about the book that you're writing, about if your work if you work hard to make the world more just, or to find a cure for cancer, or to write music. It's going to be very difficult for you to go on feeling commitment in that way if you know that it's going to just finish like that arbitrarily. Valuing, he says, is a diachronic phenomenon. And what we see is that when we value something, we thereby acquire a stake in how things will run even after our death. And this is the stake that we have in what happens after our death. And if we don't have that, then as humans, that's just the way humans set value, then we won't be able to set value and create value. And our life is going to be more flat, grey, and boring. Now, how does that get us to the posthumous trust? I will want to go now through, so we talked about it before, about the menu of justifications. One actually of the best justification for property, for the institutional private property, is given to us by Hegel. So Hegel is famously a complicated philosopher to understand. I'm going to say just something about it. In what may be the most famous sentence in the philosophy of right, Hegel says, persons must translate their freedom into an external sphere in order to exist as an idea. What he means by this cryptic sentence is probably that Kant was wrong when he thought that you can have all the value here, that you can value aspects of the world and everything stays in the mind, maybe in some kind of interaction with minds of others, but have no physical expression out there. Hegel says no. You can have this kind of value, but that's not going to be the real potential the valuing has. If you want to create aesthetic or moral or any other value out there, it must have expression in the external environment. So if you plant a garden, if you bake a cake, even if you write a book, if you decorate a house, if you collected pictures, all these will be expression of different values that you find out there. And moreover, he says, it's not only that you find expression out there, but the physical environment, physical objects in and of themselves, they don't have a value in and of themselves. The only way they can be valued is that if we imbue them with value. And after I collected the pictures and I baked the cake and I planted the garden, this garden can only be understood as valuable with reference to myself. This is the garden that Vicky planted. This is the book that Jenny wrote. And in that way, physical aspects of the world become valuable. And this all has to do, of course, with property. Because in order to really set value onto stuff around us, we need control over them. And the control can come from the way the law is giving us the right to private property, to have it for ourselves for a long time, to be able to decide what to do with it, and so on. And in that way, the posthumous trust and the posthumous trust, what it does for you is allow you to imbue different pieces of property with value, and know that this value will not suddenly expire because you happen to die on a specific date. No. Think about a collection of art that you have. You didn't create the art, but this collection, collecting it in this way, is something that is very dear to you. And what the posthumous trust allows you to do is to say, I want this collection to stay together. And in that way, the value you can't do this forever, of course, but you can do it for a bit, for 80 years or so. And in that way, the collection or the house that you decorated or the garden that you planted can have and sustain the value along a line that is natural to this value, and allow you to be committed to value and to value through property in a deep way. And therefore, the owner's wish to take part in writing the agenda for the property after the death is just can be a benign corollary of the way we set value onto the world. Without being able to commit in this way, our life is going to be much more poor. That's it. Thank you very much.
Thank you very much, Irit. Trust is fun. Who knew? It's a really fascinating insight into your work, and also some of your thoughts on this really interesting area. So thank you so much. As our Dean said at the beginning, unfortunately he had to go to another event, and so it falls to me and Paul James Cardwell, the Vice Dean Education in the school, to do the transition with costume changes and stairs and all of these hazards to our next speaker. And the inaugural lecture is a double bill, it's a great pleasure to introduce Professor Anne Mumford to give your inaugural lecture. Thank you so much.
Thank you so much. Thank you, Paul and family and friends. I'm really just very thrilled to address you this evening. From a brilliant introduction to ideas on dead hands, to dead ideas in U.S. constitutional law, taxation, trusts, and perhaps a bit more. Taxation law in the United Kingdom is very principled. Horizontal and vertical fairness in terms of how much we pay, of course. But I'm actually thinking of ideas that are a bit simpler than that. Tax should take as little out of a man's pocket as possible. And while we're in a man's pocket, don't look around and respect financial privacy. Now, the first idea belongs to the Scottish Enlightenment philosopher Adam Smith. And the second idea is a bit more recent. But on the first, if one looks closely, it's possible to discern some of the magic of taxation law in the United Kingdom as an intellectual discipline. To whom does the pocket belong? Well, a man for certain, but that's another lecture. What kind of financial privacy are we discussing? Well, that's where things get interesting. For example, another of Adam Smith's principles is that taxpayers should contribute to the public fisc according to their ability to pay. Now, this idea is found in constitutions around the world. It's not, however, found in any of the legislation which collectively form the small c Constitution of the United Kingdom. Here, it's just an idea. It's discussed sometimes, but not as frequently today as, say, horizontal and vertical equity. So in Sweden, for example, if one asks about the foundational principle of their taxation, one will be directed to ability to pay, Adam Smith's words, in their constitution. And in the UK, Adam Smith is a writer from the Scottish Enlightenment. The UK tax system is ancient and dates back farther than the country itself. Smith is a writer amongst many. And it's no wonder that writers from Schumpeter to Piketty have found themselves drawn to the ideas behind UK tax, often starting their investigation with its ancient tax on inherited wealth. Now, the dead hands of which Irit spoke so eloquently may control the availability of property within the reach of tax. Now, in property, these too are ancient ideas. The ability to do what one wishes with one's own property, as against a king, sits at the foundation. But there are claims to be balanced, to fairness, to expectations, to history and to conscience. And tax sometimes is ignored in the process of this balance. And so to explain this, gaps have been filled in retrospectively. So, oh, look, the country turned to taxing consumption in the 13th century, so we can ignore the role of tax in discussion of robust property rights. It's not always been like that. In the 19th century, the turn away from death duties to estate duties was slowed, albeit briefly, by worries that a more robust form of tax might interfere with rights of ownership. The worry abated, but the discussion was had. Then, today, with our modern focus on economic growth, such discussions are far less common. Now, the United States followed a much rockier path. Of course, no taxation without representation was at the start. But once the natural law purists achieved their revolution, placing Magna Carta at the core, their own vision of representation was realized, but taxation remained unclear. When their vision of multiple governments turned out to be imperfect, they created federalism, promising states that had formed governments based on common law that they could continue that model. Indeed, they could expand upon it if they wished, but would need to do so within a system of tiers, coordination, and cooperation. Now, there's always a danger that process will come at the cost of principles, especially when process is revered. And so the Bill of Rights, the first 10 amendments to the American written Constitution, aimed to take what was best and most exciting about discussions for the future path of English law. So, hello habeas corpus, hello Entick and Carrington. Protect these claims and thus entice skeptical states to sign up. Taxation was not mentioned in the Bill of Rights, but elsewhere in the Constitution. Elsewhere, we find controls on direct taxation from the federal government, states remaining free to tax as they wished, as long as it didn't interfere with interstate commerce. Apportionment requirements, so as to preserve equal treatment between the states. And the protection of slavery through the 3/5 compromise, requiring that enslaved persons would be treated as 3/5 of a person for the purposes of taxation and representation in Congress. Now, following the American Civil War, the 13th and 14th Amendments would remove the 3/5 requirement, and a few decades later, the 16th Amendment would remove direct taxation barriers, preventing a federal income tax, an innovation upon which Brussels consistently looks longingly. But notice, if you will, other than the removal of slavery as a foundational tax principle, and perhaps slavery was the only American foundational principle in tax at the start, the absence of anything to replace it. No ability to pay. Nothing. Now, perhaps in this, they're not so unusual. A key foundational principle of tax in the UK is that only Parliament can tax. So principles should not restrict democracy, except there are principles. And they're needed for the rules to make sense. And so I look for them. And here's how I sometimes find them. If I have a few minutes to myself, I will often search recent decisions of the UK and US Supreme Courts for the word tax. It's actually not a bad way to spend a few minutes. And a bit of a nerd, but one realization I've reached over the years is that there are no false positives, especially when tax is discussed in cases where I really wouldn't expect it, and especially in the US. And I would like to share with you, for the remainder of this lovely for me event, one example. In 2019, I was surprised to find a reference to tax in a US Supreme Court case about a man named Terrence Gamble. In a routine traffic stop, officers in Alabama noticed a gun in Gamble's car. As a felon, he was not allowed to possess a gun. He was prosecuted in Alabama and received a sentence that apparently was not long enough. So the federal government prosecuted him as well and added much more time. Gamble appealed his 2 convictions to the US Supreme Court. Now, the US Supreme Court faced a quandary. On the one hand, over the past 100 years plus, successive decisions have held that principles of double jeopardy do not apply to federal and state prosecutions. Yes, one can be prosecuted twice in the United States for the same crime, once by the federal government and again by the state. Although, to be honest, it's often in the opposite order, as the federal government typically will prefer to watch a rehearsal of their case in the frequently less well-funded state prosecution and then have their go. Without the doctrine of dual sovereignty, as it's called, the idea that although the federal government itself may not prosecute a person twice for the same crime, it's the same for the state, the federal government and the state government each are treated as separate sovereigns and thus are out of reach of the double jeopardy provision of which you may have heard in the US Constitution. But it's complicated. Without the doctrine of dual sovereignty, as identified or perhaps created by the US Supreme Court, significant wins in civil rights and against organized crime would not have occurred. So, whither the quandary? Well, I suspect many in this audience may have heard of the originalist turn in American Supreme Court jurisprudence. Now, this has occurred in recent years, and the historical basis upon which, having assessed that 18th century founders may not have supported abortion, Roe v. Wade should therefore be overturned. Now, having achieved the difficult task of the ratification of the Constitution in 1791, do we really think that the founders would have approved dual sovereignty? But we must remember that federalism is a wholly new American, newfangled idea, but the old English ideas formed the vocabulary of how Americans talk about law. English legal ideas from the 18th century are needed as a dictionary. Now, under the current American Supreme Court, these ideas have served as prohibitions against any action from their 21st century court that would not be recognized by an 18th century founder. So how did a reference to tax find its way into a case about Terrence Gamble and his gun on the back seat? Well, it was a simple allusion in the US Supreme Court decision to the fact that, as both federal and state governments are allowed to tax, so they should be allowed to conduct criminal prosecutions. Now, there was actually an ancient English case on the point of double prosecutions, which the Supreme Court discussed at length, R.V. Hutchinson, from 1677. Now, the way that the majority discussed the decision stopped me in my tracks. Hutchinson has been a quiet but steady reference in English courts for centuries, supporting the proposition that where an Englishman named Hutchinson murdered another Englishman named Colson in Portugal, an acquittal in Portugal served as a bar to a prosecution in England, despite the king being pleased to have him tried in England. It's a pretty surprising decision. Such deference from the late 17th century English court, and so little detail. Why? Is this just for Portugal or for all other countries? Is this just for this man Hutchinson, or can any English person make this plea in bar of prosecution? Now, a statement repeated at the time of the early years of the American Republic was that they had not just fought a war to lose the rights of Englishmen. So yes, for example, Magna Carta is a source of law in America. The Hutchinson decision is a right of Englishmen. Could Terence Gamble claim it? And if he did, how could this originalist court deny him? Here's how. In a decision written by Justice Alito, the majority held that the evidence for Hutchinson deciding what had been claimed by the English courts of their own decision and their own history was paltry. What Justice Alito wanted to see was the actual decision, not a description of the decision in other cases. In the absence of that, he ruled that the evidence that Hutchinson decided what the English claimed could be ignored. Yep, you heard me correctly. So this was surprising to me. So much so that in the early days of lockdown, I padded from my desk at home to my husband Peter's home office and asked if he could show me how to find the Hutchinson decision, probably because I felt like tweeting it or something silly like that, possibly at US Supreme Court. And having been married to a proper English legal scholar for 30 years this month, there is one consistency in our discussions about law. He has said to me repeatedly, you can always find the case. Don't tell me you can't find the case. We live in London. Go find the case. Read it, and then let's discuss it. Peter couldn't find the case either. So it was a bit weird. So stuck at home during lockdown, I became a little obsessed. And after searching for more time than I ever could have imagined, we eventually found it. And here is what we learned. This was the O.J. Simpson case of its day. Everyone knew about the crime. Its details are so vivid that they honestly jump out of the council minutes for King Charles II and have been discussed by historians who didn't make the connection with the case because of a misspelling in Colson and Colston, more on which in a second, and have formed the basis of, for example, romance novels. The dastardly Alan Hutchinson, from a distinguished family, is trading in Portugal, wine, slaves, and more. There he joins the community of English merchant venturers that includes fellow gentleman William Colston, not Colson, brother of Edward Colston, philanthropist and benefactor of Bristol, who you may have heard of. He, more recently, of the River Avon. His statue was thrown in there during the George Floyd protests all the way back in lockdown. Now, Alan Hutchinson and Edward's brother, William, had a dispute over a game of dice, which, morals of the time, led to a lawsuit. This would have been pretty scandalous, so it's not surprising that they resolved it. And in the language of the time, it was burnt. Now, this was long before the fateful day in December 1675, when word started to spread through Lisbon that William Colston was headed back home to England. Packed up all of his things, one-way ticket back. Honestly, the heavy drinking engaged in by Alan Hutchinson starts to jump off of the manuscripts at this point. He apparently stumbled around until he found Colston and demanded to know if he would fight him. Colston responded, "I will not fight a child." Hutchinson drew a knife and stabbed Colston to death. And Colston died 6 hours later after suffering greatly throughout. He was surrounded by his friends who witnessed his agonies. This was an enormous scandal. A government official named Francis Parry, very distinguished in his own right, became involved, convinced Colston's friends not to take justice into their own hands, told the Portuguese authorities that the wretched and self-pitying Hutchinson could be found hiding in a local church. Parry liaised through vivid letters with Colston's family. And who could blame William Colston's father, also named William, for wanting justice? His son's body was sent home preserved on the same boat on which he had booked his one-way ticket home. He was buried in the family tomb in All Saints Cathedral in Bristol. Now, politicking began immediately back home in England. Parry assured friends of Hutchinson that, because he was a gentleman, the Portuguese were unlikely to execute him, but also stressed that he wanted Hutchinson to be convicted and punished because the crime was so heinous. The Portuguese, thus, who probably wanted nothing to do with this mess, were pressured to proceed. See, the Queen of England, Catherine of Braganza, was the sister of the Prince Regent of Portugal and daughter of the king. She lived at Somerset House with her Catholic priests in the 17th century. It was a very challenging life for her. The prince would have had no desire to make life even more difficult for his sister, so he was happy to aim to please his brother-in-law's emissary, Parry. There were a couple of problems. First, Hutchinson's uncle, Alan Apsley, was the treasurer to the Duke of York, Charles II's brother. Apsley not only applied significant political pressure to save his nephew, but also probably successfully bribed the first Portuguese jury into acquitting Hutchinson for Colston's murder. Frustrated, because remember, Parry wanted Hutchinson to be convicted, if not executed, the Portuguese tried Hutchinson again, but doubled the amount of Englishmen on the jury. Alan Apsley's pockets were so deep that Hutchinson was acquitted a second time and booked a quiet journey home. Somebody, we don't know whom, but have suspicions, it's going to be Parry, told William Colston's father that Hutchinson was on a boat headed home to England. Colston approached the king, an old friend. Colston was a Cavalier during the Civil War and had suffered much for his support of Charles I. Hutchinson, the king knew Hutchinson, knew his family. This is a very blurry picture of the death warrant for King Charles I. Here's how AI says it would have looked back in the day. And I'd draw your attention to, where is it? It's over here. Second column, Hutchinson. Now, that's actually the signature of Alan's uncle, but his uncle and father had fought against the king and had played a pretty significant role in the execution of Charles I. This was the family, the Hutchinson family, from which Alan came, and he was now asking Charles II for mercy. So what did the king do? Had him arrested when he arrived, heard evidence in the form of a trial, and asked his judges to rule whether evidence of an acquittal in Portugal, produced with an official seal, was a bar to a prosecution in England. And do you know, they said it was. Here's the decision. Hutchinson was released and, disgraced, headed back to Lisbon, where the prince took pity on him and offered him a pension, again, probably in deference to his sister, the Queen. Hutchinson occupied his remaining days serving as an English translator for the Portuguese police when they, from time to time, tortured the ever-scandalous merchant venturers. Everyone back then knew about this case. George Washington is a descendant of a witness in the trial before the king. The details were discussed for centuries after. But eventually everything is forgotten. Now, Peter and I wrote up and published the details of the Hutchinson decision, and a justice in the Fifth Circuit in the US recently wrote in a decision that it remains to be seen whether the U.S. Supreme Court will consider our evidence when the issue is considered again. Justice Reeves warns that the U.S. public is losing faith in an originalist court who sometimes gets the history wrong and essentially urges that the finding be considered in the context, of all things, of a Second Amendment gun rights decision. Now, if a decision is issued today in either the U.S. or the U.K., and O.J. Simpson is mentioned, there's not going to be a paragraph. We all know who he was and what happened. The same was true for Alan Hutchinson, except he eventually was forgotten. As will O.J. Simpson be forgotten, and I guess all of us, no matter how grand. And I suspect many of us may not have known that we are sitting in the late Queen Catherine's house, or that she lived here with priests during a time when her infertility was being blamed by conspiracists as somehow a Catholic plot to overthrow the monarchy during the fragile Restoration. The rules and process left by history linger while the principles fade. We don't know why the king's judges decided as they did, because typically for the time, the recording of the decision by a barrister listening in when it was being delivered, it's pretty brief. We do know that the judge's decision in Hutchinson was followed by courts in the UK for generations, which is a testament to how it was viewed who lived closer in time to it than we do. We also know that there's a grand irony here that hardly needs stating. Terence Gamble attempted to claim a right of Englishmen in 2019 before an originalist American court that suggested that everything turned on what rights had been afforded to the slave trader Alan Hutchinson in 1677. And the court denied the evidence before it and said that they did not believe that Englishmen indeed had the right to use an acquittal in Portugal as a bar to a prosecution in England. They perhaps could not believe that 17th century law could be so progressive. Now, it would appear that when the principles fade and the rule remains, it's easier to deny what the rule, in fact, says. So what for tax or trusts? Two subjects that have nothing and everything to do with each other, never mind murders of Englishmen by Englishmen in Portugal. Subjects about community and individualism, private property and public distributive justice. Charles II would have said that tax was about his ever-increasing need for funds, but again, that's another lecture, one that would address the formation of rebellion in the colonies. For now, I would like to end this lecture by sharing something with all of you I've been really keen to share with someone. Now, while Peter and I were waiting for our article to come out, I would dream a little bit about how fun it would be on the great day to send a couple of email messages. First, to Terence Gamble's lawyer, letting him know, as he must have known, that he was right to trust that the British were correct about their own law all along. Second, to Bristol All Saints Church, for a weird reason. During the long period of research for Hutchinson, I believe I solved a bit of a smaller mystery. In the 1800s, long after the deaths of everyone involved in this story, All Saints was refurbished, and the restorers removed what they believed to be the tomb of Edward Colston of the river at Avon. Now, Colston had died without children and inherited all of the money of his wealthy father, as his 10 other siblings, including his poor brother William, predeceased him. Edward spent a very great deal of money on charity in Bristol, so he was revered in the 19th century. The restorers couldn't believe what they found. Edward Colston was perfectly preserved. Townspeople ran in to see the miracle, and even, I'm afraid, removed pieces of his clothing as relics. It was unseemly. A local artist drew a picture of the body, and here it is. Eventually, elders told the citizens of Bristol to calm down. Although the face looked exactly like philanthropist and slave trader Edward Colston, his clothing revealed someone who died in the 17th century, which Edward did not. Also, his teeth, as you can probably see, were too youthful to be those of a man who died in 1721 at the age of 84. I suspect you've all reached the same conclusion that I did. This isn't Edward Colston, it's his poor brother William. Because remember, William's body was preserved for that sad journey home to England. Now, the 19th century Bristolians never figured out who this was. So I settled down to write an email to the current pastor of All Saints in Bristol, excited to show off a bit. And I discovered that although one can tour the church today, and it's beautiful, no one worships there any longer. Literally no one cares. Everyone has moved on. There was no one to tell because simply no one now cares which 17th and 18th century Colston tomb belongs to whom. They and we have all moved on. And I think there may be something in that. And perhaps what is certain is that the challenges of the present are far more important than distilling principles from the very distant past. Thank you very much.
Thank you very much. We learned that trust is fun and also taxes is fun. People will be queuing up to teach this next year. Oh. Colleague, yes. So thank you again, both speakers. This was an amazing event and a continuation of our inaugural lecture series, which continues later in 2025 with more of our professorial colleagues. As we said at the beginning, one of the advantages for the advantage for the speakers, apart from free wine, is that there are no questions, but you are free to badger them during the drinks, which will be served at the back of the hall. Thank you to you all for coming today to this evening's double bill inaugural lecture, and I would invite us to applaud our speakers, our excellent speakers, once more.